room. Are we live yet?
Yes.
Did God say yes?
Yes.
God said yes.
Okay. All right. Then, it being the appointed hour, I hereby call to order the regular meeting of the Ojai Planning Commission for Wednesday, November 2nd, 2022. Who's in the back room? Oh, is it
Sherry.
Sherry? Okay. Oh, hi, Sherry.
Hi.
Would you call roll, please?
Chair Quilisi,
Here?
Vice Chair Bennett,
Here.
Commissioner Trent,
Here.
Commissioner Murphy,
Here.
Commissioner Starkweather.
Here.
Terrific. So we have a quorum. Commissioner Trent, if you'd lead us in the pledge?
Yeah.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Next on the agenda is public communications, the time set aside for discussing items of city business that are not on the scheduled agenda. I have no cards in front of me indicating anyone here present wishes to speak. Sherry, do we have anyone in the waiting room with a raised hand?
No.
All right, very good. We'll move on then to the consent item, the minutes of the regular meeting of the Planning Commission, October 19th. Any refinements from commissioners?
Nope.
Then a motion to approve would be in order.
I
I think I may have sent a couple of typos or something to Sherry.
We'll incorporate those into
Yeah,
Judy's
as amended.
motion. I'll second.
All right, we have a motion and a second. Any discussion? Sherry, please call roll on item number 1.
Quilisi,
Yes.
Bennett,
Yes.
Trent,
Yes.
Murphy,
Yes.
Starkweather.
Yes.
Thank you all. Disclosure of site visits and ex parte contacts. Commissioner Trent?
Familiar with the site, no ex parte contacts.
Okay, we have 2 sites tonight.
Oh, yes. Familiar with the second site as well.
Okay,
No ex
very
parte
good,
contacts.
very good. Vice Chair Bennett?
I too am familiar with those sites and have had no contact.
Very good. Sir?
We're at both sites the previous time they were on the agenda, but I haven't been back since, and I've had no contacts.
Good. Ms.
Same thing.
Very good. And likewise, I'm very familiar with both sites, have had no ex parte contacts. Thank you all. Let's move on to our first public hearing item then. Lot line adjustment at 214 Bryant Street. Maura?
Thank you, Chair Quilisi and Commissioners. So this is a lot line adjustment, number 21002. It's a request for an adjustment of an existing property line that divides 2 existing legal non-conforming lots. The current location of the lot is through an existing building. The adjacent lot line, or excuse me, the adjusted lot line will be relocated, avoiding all existing buildings. On July 6th of this year, the Planning Commission reviewed and considered this request and continued the item to August 17th with direction that the applicant work with staff to procure a Phase 1 environmental site assessment related to the potential of existing underground tanks identified within a radius map report that was presented at the Planning Commission meeting by one of the commissioners. When staff appeared before the Planning Commission on August 17th, the applicant had not provided the Phase 1. However, staff contacted Rincon Consultants, who is the firm that prepared the Phase 1, and was able to obtain the document. Rincon Consultants maintained that the information in the radius map, which was actually part of their information in preparing the Phase 1, which had indicated that there were 6 underground storage tanks, was likely inaccurate, and they stated that the only way to determine accuracy was for a geophysical study to be performed at the site. So at the August 17th Planning Commission meeting, the Planning Commission continued the request for approval of the lot line to an uncertain date, asking for or directing staff and the applicant for 4 different things. One was that the applicant obtain a geophysical study of 10 feet on both sides of the proposed lot line to indicate whether or not there were underground storage tanks in this location. And the applicant contracted with GPRS, and they prepared a summary of scanning for underground storage tanks. And the report was submitted to the Community Development Department on October 3rd. The report finds that the subsurface conditions at the time of the scanning allowed for a maximum depth penetration of 2 feet in areas, and that the equipment and methods used did not detect reactions that are potential for underground storage tanks. Since then, staff did a little research to find out what the normal depth of study for finding underground tanks, and found that cover over a tank would be about 2 feet. So the second thing that the Planning Commission asked for was that they directed staff to obtain a C of O, a certificate of occupancy, for a building addition. A C of O was not the document that was processed for the addition to the building. A building permit, however, was processed for the close to 3,000 square foot building addition in 2010. The building permit was reinstated, and the building permit was finalized to legalize work that had been done without the benefit of permit on April 5th, 2022. Another direction was that staff follow through with previous requirements by the fire department, the Ventura County Fire Department, for fire sprinklers, and found that on October 18th in 2019, a letter of compliance agreement extension was provided by the Ventura County Fire Department. Actually, it was the Ventura County Fire Protection District, and they required installation of a previously approved fire sprinkler system or removal of all fire sprinkler system components to be followed up with inspections. And then on January 7th in 2020, the Ventura County Fire Department conducted an inspection and approved the correction and closed the case. However, I'm hoping I'm not going backwards, in May of 2022, the Community Development Department received notice from the Ventura County Fire Department that the building addition was previously approved and the owner was required to remove the exterior sprinkler protection components as well as all interior sprinkler heads. I tried to put those different things in order. The last thing that the Planning Commission asked for on August 17th was that the applicant obtain a Phase 2 study. And the applicant has not submitted a Phase 2 study. However, it was made evident in the recorded discussion of the Planning Commission meeting on July 7th that the information being sought was whether or not there were underground tanks. And that would be found out by by a geophysical study, as opposed to a Phase 2 study, which would be more for finding out about soil contamination. So the report by GPRS did not detect potential underground storage tanks, as already reported to you, and the Phase 2 was not followed through with, nor was it discussed or pushed to do by staff, because it was whether or not underground tanks were there was what the issue was, which the geophysical study took care of. So having said all that, per the Municipal Code of Ojai, Section 10-3.11, that's for lot line adjustments, the Planning Commissioner's review and approval determination of a lot line adjustment shall be limited to a determination of whether or not the applicant has complied with provisions of this section of the Municipal Code, and that the parcels resulting from the lot line are not resulting in a greater number of residential development parcels, which this is not, that the lot line adjustment will not increase or make more onerous any violation of the zoning regulations, which it is not. They're conforming lots that will remain conforming after the lot line adjustment. That no condition or exaction may be imposed on the approval except to cause the resulting parcels to conform to city codes. No tentative map or parcel map or any other final map may be required as a condition of approval. And with that, and the information regarding the underground storage tank monitoring and removal, staff is recommending that the commission approve the lot line adjustment as submitted. And we have here tonight not only the applicant, but I believe we should have 2 representatives from GPRS to answer any questions about the geophysical study. And we should have Jeremy Henry here, who's the surveyor who prepared the lot line adjustment. That was long, I'm sorry about that.
Okay, no, it's a complicated process. Do we have any questions for staff?
I have a couple, but the first one is, and maybe the person who did the study would find out, so this geophysical study goes down 2 feet, but you have found that...
I think it said in most areas.
The geophysical study goes down as far as it's able, and because of the soil conditions, in most areas along this line, it was able to go down 2 feet.
And then you said that tanks are usually in the range of 2 feet.
It's not uncommon for the cover over the tanks to be approximately 2 feet.
I see, but it could be lower. Okay, just want to check.
And we do have after we're finished with asking questions from staff, we do have the expert.
Yeah, okay, I just wanted to go from what we have here. Phase 2 mentions obtaining and testing soil samples, soil vapor, and groundwater for pollution with a geophysical study can, while geophysical study can do something else. Anyway, at what stage in our planning process would we require a Phase 2?
Phase 2 might be requested between the seller and buyer, but that would not be part of staff's or the planning commission's issue with a lot line adjustment. That would be something.
No, but so at some point, if someone were to develop on it, then we would get that information.
We would not be requesting that. I'm sorry. I'm sorry. Yes, if somebody were developing that lot,
Okay.
and coming in here with development plans and an environmental assessment was prepared, then yes, we would be looking for soil contamination.
And on page 5 of 6, it says the use as well as zone and land designations are light industrial and do not include residential developed parcels. The parcel is not a building site. What does that mean?
That the parcel is not a building site?
Yeah.
Well, right now, we're not looking at any development, we're looking at a lot.
So
line
there's no
adjustment.
building on it, or no one's proposing to
there-
build on it? Is that what
No
that
new
means?
building.
We don't have
proposed.
any building plans proposed at this time that we're
Okay.
reviewing.
And the parcel is designated as non-residential purposes, including but not limited to well sites, reservoirs, and roads. So it sounds like the lot line adjustment is dependent on this being non-residential.
The lot line adjustment doesn't, the line
Well,
adjustment is,
the definitions have it as being non-residential as to what we can approve it under these circumstances because it's non-residential. So that would seem to imply that if it's going to be residential, then we should have a different standard.
Yeah, lot line adjustment doesn't necessarily identify a zoning characteristic as residential versus manufacturing versus commercial. It's more as it relates to the development standards itself and the findings that Mara had just referenced earlier. There's typically the 4 findings. It's consistent with the general plan. It's consistency or not creating a greater number of lots. It's the zoning regulation setbacks, the development standards that we had just mentioned earlier. And then we can impose a condition that requires it to become a map. Those are the 4 pieces when you're looking at findings for a lot line adjustment. They don't necessarily waver between zoning districts. They waver within those specific findings.
Okay, well, I'm just a little puzzled why it would have that as part of the definition of what a lot line adjustment.
What
shall
definition
not-
are you looking at?
Well, I'm reading page 5 of 6, says a lot line adjustment shall not result in greater number of residential developable parcels as existed prior to the adjustment.
Yeah.
The use as well as zone and land use designation are light industrial and do not include residential parcels. Then you've got a quote apparently from the statute or from the code. The parcel is not a building site, or the parcel is designated as non-residential purposes, including but not limited to well sites, reservoirs, or roads. So why is that in there? If it,
I think it's a blanket on all lot line adjustments for all
They're
zones.
quoting 10.3.11 here,
I see.
which says
Okay.
if this is residential property,
Yeah,
then you can't create more residences by a lot
I
line
see.
adjustment.
Okay.
Yeah, that's a subsection to the findings.
So it's,
if
that
residential.
point is moot because it's not residential property.
Okay, okay.
Other questions, Mr. Trent?
oh, yeah, sorry, did you want to go first? Okay, I'll go. Just to.
On this way.
That's okay. A question on page 3 of 5 on the resolution.
5, that's in the resolution?
Yeah, attachment A, 3 of 5. Condition 5, the applicant property owner prohibited from use any portion of parcel A or parcel B for short-term transient vacation rentals for a period of time less than 30 days in exchange, yada, yada, yada. And then it goes on to cite Title 10, Chapter 2, Article 4, Table 2-2, which is a list of available uses into the residential zones. But this is not a residential zone.
This is not a residential zone, and you know what, it's just a kind of a blanket condition that finds its way into most resolutions.
And
It's a standard condition that we
Yeah.
place on nearly
But
every
it doesn't
application.
apply to
Okay.
this property since it's not residential.
Yes. However, I want to note that in the future, if there was any sort of residential uses that were to be allowed,
yeah,
we are going through the general plan update. I'm not saying that that's necessarily going to happen.
Sure.
I think it's important that this still remain in, just as a blanket cover.
okay. And then another quick question. Does this qualify as or does the M1 zone qualify as a zone for SPL?
SDL.
It does.
It could.
It could.
Yes.
Okay.
Could.
So,
In the M1, we have one site that's SPL overlay, that contains an SPL overlay.
okay, so we have one site that contains SPL overlay. So this could be a potential site for SPL overlay.
This was discussed with the planning commission back in June
Yeah,
of, if you recall, of last year as one of the potential sites.
okay.
But in terms of the housing element, never ended up going forward,
Right,
but certainly was discussed
got it,
and considered.
got it.
And wasn't a couple of sites on this road considered, but they were rejected as potential
Correct. There was one
arena
across,
sites?
yeah, there was one across the street as well.
Okay.
So
And there's one still existing at 324, I think it is,
It's a vacant lot, yes.
a vacant lot
It connects to Fulton Street. You're talking about that one?
that does have an SPL overlay.
That's one of them, yeah.
Yeah.
That was considered but not approved.
Ms. Murphy?
Staying on that same page, attachment A, page 3 of 5, item 3, what is a wet stamped map?
That's an original signature,
Okay,
so by a surveyor or other professional.
all right, thank you. Also, on page 2 of 6, where you are discussing the Ventura County Fire Department removing all of the, or telling them to remove the sprinkling system. That's a commercial building with hazardous waste. How can we not have fire protection?
I would like to be able to speak to the fire department's condition, however.
Look,
But if it's our commercial building code, how can the fire department just blow it away?
so that was a condition that they imposed on it. We ended up going out and doing a final inspection once they removed all of the fire sprinklers. So essentially, we're talking about putting something in, looking at a permit, and effectively energizing the water, but then realizing that that wasn't something they were wanting to move forward with.
Who wasn't going to move forward with it?
The applicant.
The
They ended
applicant.
up not moving forward with
Okay,
it, so
but
they
the
had
app-
to remove all of the pieces. So in
Okay,
terms
so
of the
we have a
fire sprinklers
commercial
had to be removed.
hazardous waste site without fire protection. Is that correct?
That was something that was identified through fire department, correct?
blows me away.
Yeah.
Oh, and there's more.
More?
Sorry, this whole report was, I didn't quite understand you, Maura, talking about number 2, a certificate of occupancy. Were you saying that that never happened, but a building permit did happen?
That's correct. At
Did a
that
final
time,
inspection on that permit ever happen?
yes, and
did.
they just didn't proceed or process it with a C of O. But they did get a building permit and a final inspection.
Okay, that's all for now.
Okay. Jake?
I've got a question about the authorities here. I can certainly understand the reason for making sure there is no tank on the lot line, so we don't have disputes as between the people on both sides of the lot line as to who has responsibility, and the same being for a building which straddles the lot line and making sure that the building is contained and has appropriate setbacks. But I don't understand why we are on this, I'll call it fishing expedition around the lots to see if there's, if there are hazardous wastes, since that should be in the next step, which is when somebody goes to build something, as opposed to merely establishing a lot line. And it seems to me we're doing a lot of work at a period of time when it's unnecessary and not required by any authority.
So I think the last planning commission meeting, when the planning commissioners made the decision to have the geophysical study done to 10 feet to each side of the proposed lot line,
Yep.
to stick with the fact of looking to see if indeed there are tanks or a tank near the lot line, or where the lot line would be, or straddling,
Yeah,
where the lot
I
line
have
would
no
be straddling it.
question
And so, and we ended there. And that study has been done, and we have the determination by the study, and we have the professionals here to speak to that study. And I think we've stayed in that 10 feet on each side of the line. And with that determination that was made by GPRS, staff's recommending approval of the lot line adjustment because they found that there are no tanks straddling the lot line.
Going beyond any of that, in terms of whether there are additional tanks on either one of the sites, is beyond what this lot line adjustment is looking to accomplish. We're moving one line from one location to another.
That's what I thought.
In doing that, the phase 1 did identify that there was the potential, right? Identifying what, six tanks potentially on the site, not accounting for the 2 that were moved in 98 or 97. So that's where staff felt the need to do the due diligence and to have that study done. And then that study then came back.
But why that? In other words, I
For the-
understand
for
when
this-
it's close to the lot line, but why?
Straddling the lot line would then create a potential issue with the city getting involved, identifying itself as tanks being over 2 lines that the city had just approved. So in order for us to feel comfortable, to get to a level of comfort, and also to meet the findings in terms of what we're looking at here, in terms of development standards being met, in terms of the general plan being met, those are the findings that we're held to. Tanks being on either site, outside of that lot line, that new lot line that's being adjusted, outside the purview of the city, unless they come forward with the development, and then we start looking at
That's my-
phased
that's my
environmental
point.
assessments, correct.
Okay, thank you.
Well, and correct me if I'm wrong, but this wasn't in this review, but in the first time we looked at this, there was a purpose outlined that there was potential for a sale. That was one of the reasons this was being looked at.
Typically, when you do a lot line adjustment, there's
Yeah.
the potential option.
That's why-
Prospect of a
That's why we
sale,
wanted to
for
look
sure.
at the line to make sure there wasn't a tank in the middle of it, because that would create legal issues.
Correct.
Okay. I have one question for staff and one, I think, for the city attorney. Back to what Vice Chair Bennett was just talking about. If it turned out, and we haven't established it, Maura said the study showed there were no tanks there. What it showed was they couldn't find anything down to 2 feet. But if there were tanks or areas of contamination as a result of tanks that spanned the lot line, Epi, and someone decided to sue on the basis of contamination, would the city be logically a party to the suit for having approved a lot line that crossed an area of contamination? Or would that simply be a dispute between two private parties not involving the city?
Right. That's a good question. I can't speak to what they, a potential
I mean, I
buyer
know
would
anybody
attempt
could
to
sue
do.
anybody
Right.
anytime, sure.
Right.
But
I would say that the city would have a pretty strong argument based on, the indemnification clauses in the lot line adjustment, and depending on whatever is in the contract between the buyer and seller.
there is a standard indemnification in the.
I believe so. Yeah,
So
I'll double check.
if we make the lot line adjustment and then somebody buys the front part of this parcel A, I think it is now,
Yes.
and then sues the owner of parcel B, then the owner of parcel B would indemnify the city for having approved the lot line adjustment? Is that what this clause means?
Yes, correct.
Okay. Yeah, and I guess my question for staff is, I'm sorry. My question for staff is, you've quoted 10.3.11 to us. If I read that and take it at face value, that says to me that what's under the ground, whether it's spanning the lot line or not, is no business of the Planning Commission. Is that your conclusion? I'm not just asking the question, because when I read 10.3.11, and I went back and pulled it off the website too, it doesn't say anything about contamination. It just says, are you creating more residential lots, or are you otherwise complying with the general plan and the code? And I think of groundwater contamination as kind of a public safety thing. Where is it that the Planning Commission is, let's say, properly concerned about that issue, if not here?
I'm going to attempt to answer that. And so 10.3.11 is,
That's subdivision regulations, I think,
right,
isn't
well,
it? Yeah.
for lot line adjustments specifically.
Right.
And you're right, it doesn't talk about what's under the ground. It's very specific with those four findings which this project is meeting. I think that the Planning Commission and staff was, the words that come to mind are like due diligence and good faith and appropriate, and looking forward as far as requiring that we make sure that there's not, well, we do the best we can to make sure that there aren't tanks underneath the lot line that we're potentially approving. So I think that's just goes beyond what the findings are in the municipal code. Is the Planning Commission required to do that? I'll look over to the attorney, but I think not.
Well, required is one thing, allowed is a separate thing, and that's what I'm asking. If in fact groundwater contamination or potential contamination is a matter of public safety, is there some place that it's appropriate for the Planning Commission to get involved in at least asking about it?
I don't think
it's not in 10.3.11.
Right. I don't think it comes into play with a lot line adjustment. I do think it comes into play with development of the property, which would require an environmental assessment, and that would go into the phase 2, perhaps even phase 3 and 4, depending on what they find in a phase 2. But that would be with development and not a lot line adjustment. We're not
Okay.
disturbing the earth in a lot line adjustment.
Can I address that slightly? I remember last time looking up the CEQA exemption, categorical exemption. And my recollection in reading that whole section was if there was substantial evidence of some kind of environmental contamination, that exemption wouldn't apply. That was my reading of it. And I don't know that we have that evidence, but, so that would be one way that you could get around the CEQA exemption,
Go into that examination
as a CEQA examination.
for any development.
Yeah.
Yeah. Is that, Mr. Attorney, is that correct?
Yeah, I mean, I think it's possible that that CEQA exemption would fail under further scrutiny. But I think that we'd have to know more about, what's underground if that was the route.
Yeah. Okay. Any more questions for staff? Yes,
Yeah,
John.
sorry, one more clarifying question. So going back to 10.3.11, under A, number 1, the lot line adjustment shall not result in a greater number of residential developable parcels that existed prior to the adjustment. And then the response to that is, the use as well as zone and land use designations are light industrial and do not include residential developed parcels. So if this has an SPL on it, if for some reason that is something that somebody wants to do, won't that qualify as a residential developable parcel? Yeah, as an overlay. So then
Yeah.
should we consider this?
Not at this time, because it doesn't have that right now. And
There
we're
is no SPL on it.
correct.
Got it. Okay.
It seems to me that at some point, if someone wanted to put residential in there, we could use this as a basis of saying that's
Yeah,
questionable.
any residential development would be development that would come before the planning commission. Yeah,
Okay.
And any further subdivision would be
Correct.
coming before you.
right.
And possible further environmental analysis.
Yes,
Right.
right.
I think we're all clear now on the process, and then whatever
Okay.
possible future
The
CEQA
CEQA may
exemptions.
not
Right.
apply.
Right, but the
Exception.
CEQA exemptions
At
being
this
applied
time,
tonight are
it
just,
appears
yeah.
not to apply.
Yes, at this time.
it's just a
We have
minor
no
lot line
evidence.
adjustment exemption under CEQA.
Yeah.
Okay, if we're through asking questions of staff and the city attorney, then let's hear from, you have one more. Go ahead.
On page 1 of 30, attachment E, the Phase 1 site assessment, it's referred to earlier in the documents, and I've been trying to find where. That,
Oh, yeah.
yes, it's on, I'm sorry. It's referred to earlier in the documents that this attachment E, Phase 1 environmental site assessment, was prepared for the applicant, when in fact it was prepared for somebody named Chet Hilgers.
It was prepared
who
for a potential
who
buyer.
was a buyer, and in fact, it says that when you get to user reliance on page 9, it says this was prepared for use solely and exclusively by Mr. Hilger. So I'm surprised that Rincon released it to us, and that this is a document which we are using at this point in time. I don't know where it came from, why we got it, how we got it, but it says it's intended for use only by the client, and no other person or entity may rely on the report without the express written consent of Rincon. Did we get such express written?
So
I'm
can
gonna-
I
can I correct-
respond a little bit? If you read the conclusions of this report, none of them are really relevant to what we're dealing with because they dealt with conclusion 1, potential additional USTs and the subject property. The other 2 conditions they referenced are things that we can't consider. So this, in some
Right, so
ways, this study is kind of superfluous.
So it is superfluous, but nonetheless, it's a document
That we now
referenced
have.
in the text, which we have, which we're not supposed to have, and we certainly are not supposed to be making decisions.
We got a lawyer, he's going to protect us.
Not that you're not supposed to, but it's clear that they released the information for
is.
public viewing. So, not supposed to have is not a correct statement. I just want to correct the record.
Something more?
That's all.
Oh, okay.
I'm sorry.
Very good. Let's hear from the applicant then.
What would you like to hear, Steve?
Whatever you want to tell us.
Well, we've gone through a lot of stuff on this property, and we try to stay, within everything you guys want us to do, and we've done that. And we're just kind of asking for your blessings to let us move forward. That's basically what it
Okay.
amounts to.
Any questions for the applicant? I think we understand what's being asked here and what data we have.
Yeah, I mean, that's everything that we've provided for Mora, and I don't know if it can be anything else right now. Covers a lot.
Did you say there's someone from GPRS here?
There should be somebody virtually from GPRS.
Okay, because I'd like to ask one question along that line. The GPRS report spoke of both ground penetrating radar and magnetometer as things that were normally used in doing this kind of survey. None of the findings mentioned use of a magnetometer. I don't know if that would have penetrated more than 2 feet or not. Is there someone, Sherry, do you have somebody virtually
Yes,
from GPRS?
yes,
Can we bring him in?
working on it.
Oh, okay. Oh, I recognize that name from the report.
Hey, can you guys hear me?
Yes, please go ahead, sir.
Oh, yes. So the magnetometer, it's something that we definitely use to aid us in our search. It wasn't mentioned in the report because it's not a decisive factor when looking for USTs, because at the end of the day, it is a metal detector. So when looking at it, we wouldn't provide it as evidence that there is a potential UST there. It's more to guide our search of where to adjust our ground penetrating radar towards when we're searching an area, as do additional scans with our GPR in that area if there is a hit on the magnetometer that is able to see deeper than 2 feet, since it is a metal detector reliably. In my career, I've seen it see up to 10, 15 feet. But out on the site, there was no hit that helped me adjust with the magnetometer for the GPR to see further. As I said, the only reason it's not mentioned in the report, it's because it is a metal detector at the end of the day. There might be something down there that there was a hit, and there's no reliable means for me to say, hey, that's a UST that hit and not something else that could have just been a horseshoe that was buried decades ago.
I'm not sure I understand. Are you saying that underground storage tanks are not typically metallic, so a magnetometer wouldn't find them? Or
Yeah.
did you use a magnetometer at all in this survey?
Yes, a magnetometer was used.
Okay. And you didn't find anything?
There was stuff found, but
You
there
mentioned
was nothing-
utility lines, I think.
I don't think there's any. If there was utility lines, they weren't marked out since it was only for the UST. But for what I recall, there was no utility lines found.
Not in that 20-foot strip?
Not in that 20-foot strip. Yes.
Okay.
And then, as for the magnetometer, there was metal stuff found, but nothing concerning of a UST size. But as I said, there might be a metal fence buried. There might be something else buried. There's nothing that the magnetometer lets us read that lets us differentiate from a big metal object and a UST.
Okay. Okay. That makes me tend more toward Mora's statement they found there was nothing there if they looked with the magnetometer. Any other questions for the applicant or for GPRS?
Quick question. So, on Lot B, there's a tire shop still?
Yeah,
Okay, and then Lot A, there's nothing right now?
correct.
Gotcha.
Vacant land, yeah. Lot
It's a
B,
storage area.
Yeah, Lot B has been there for a long time. It used to be our shop.
Got it.
Yeah,
Okay.
but nothing down below.
Got it.
Okay, thank you very much, sir.
Thank you.
We do have two speakers on this topic. In order of their cards' arrival at the table here, Mr. Wyrick, you're up first. Excuse me, Dr. Wyrick.
Oh, well.
Doctor, he gets to be a doctor now.
Oh, yeah.
He's no longer a commissioner.
Now that I will elevate after leaving council, right? I'll be worth more. Okay, look, I just have some questions. I'm not trying to be difficult. It's just some things I don't understand that I'd like to understand, okay? Number one, I think this planning commission is due an explanation historically from staff as to how a building was permitted to be built over parcel lines to begin with. That's something that ought to be part of the public record to improve future deliberations and decision-making. I don't see where there's an explanation of that. It has nothing to do with the applicant, at all, and shouldn't be used in any way against the applicant. But I would like to know how it was a city permitted building on a parcel line to begin with. They said a permit was issued. How? Question one. Question two. I saw the documentation for removal and mitigation, but I didn't see a map of where those tanks were. Were they in this? Oh, is that something I didn't see?
Half-inch stack of paper
This-
that we just saw.
Oh, separate, okay.
Yeah.
Just came.
Well, thank you very much. I'm glad that you have that
Yeah, I'm
information.
gonna look at it. You can borrow mine.
If you look at,
I
if you
haven't had a
look at
chance
the
to find it
parcel
myself.
map,
Yeah. And they're away from this strip, the removals?
I'd also just interject here to note that the report which the planning commissioners have, I believe, is on the lectern as well.
Oh,
Correct. As you enter. Oh, as you enter.
I didn't pick it up.
anyway.
Excuse me.
My mistake.
Yeah,
Right,
there
so-
was a fueling island and two
In the
underground
strip?
storage tanks toward the back of, what is it called, parcel 2?
But not in this-
And up tight against the north lot line.
But not necessarily in this 20-foot strip.
Nowhere, anywhere near
Okay,
the
well, that-
proposed
that-
lot line.
That pretty much mitigates the question I was going to ask, because I didn't know where they had happened, okay? Because my point was being that, yes, it's important not to see a tank straddling a property line, but I understand the indemnification issue from our city attorney, but still, there are issues sometimes when there's a contamination plume and it straddles property lines and the city gets involved in proportionate liability litigation. So if that's not a reasonable issue to be concerned about, then good, okay? But
Right.
the way you determine that, and this is what bothers me a little bit about the staff report, the lack of tanks detected doesn't mean that a soil plume doesn't linger or residual from the removed tanks. It doesn't look like there's any real concern about this in this case, but I wouldn't want that line of reasoning to be a precedent in future cases like this, because I want to remind everyone that Texaco Station, where the mob shop was, that plume extended underneath the state highway into the parking lot at Westridge, was one of the reasons why that was such a blighted site for so long, was because the contamination plume extended across state parcel into another private parcel. It looks like there's not a lot of concern for that in this matter, especially if,
Well, in this case, the
know.
plume would in fact move
Yeah.
southward.
Right.
Which is,
but the only way to
For that area,
determine
but-
a plume, if there's any issue,
Gotta drill
is
holes.
a phase 2 soil sampling. Is the only way to determine that. I'm not saying that there's that concern here. I'm just saying, for future reference, one cannot assume because there's no tank there that there's not a contamination problem, that you have to do that with soil sampling.
Agreed.
That's why you have phase 2. Last question. This commission has dealt with issues of improperly defined utility easements. You remember some of those past episodes? Hope I'm missing that here. Where is the recorded easement for utility access to these two parcels off of Bryant Street?
I don't know. There is a third parcel. In fact, I asked staff about this
Yeah.
in a written communication over the weekend. There is a third parcel here. That parcel encompasses the western end of what we
Right.
think of as the driveway
But
to the
is
two
that a
parcels.
recorded easement for utility access?
It was called a utility easement in the admin report,
But
and
I
I don't.
didn't see
I
that
don't
on the
see
parcel
that.
map.
It's a third parcel,
But you see what I'm trying to say?
but
If
an
you-
easement is not a parcel.
It easement is not a parcel, and we have understood issues that have come before this planning commission in the past, where because the city was on top of easement access to island parcels, it becomes a problem for the city down the road. So it's just, you shouldn't isolate parcels from utilities. And is that a potential with this lot line adjustment if there's not an actual easement, and I just didn't see it? Thank you.
Thanks, sir. Second, Chet Hilgers.
Good evening, planning commissioners and staff. The planning commission's review of this application has been,
Oh, got to start over.
I'm done.
Stopped it before you started.
It's out of whack.
Looking good. All right.
Bingo.
The planning commission's review of this application has been artificially narrowed so as to avoid the conditions on and below the ground. An approval of the lot line adjustment overlooks issues that will not be addressed and will not go away. The city has known about these problems since 2019. I'm the one that paid for the report. Politicians are the first to claim they're all about protecting the environment and water supply, but rarely does anybody ever step up and do the difficult work. The owner of 214 Bryant Street has known about the underground storage tanks for decades and has been cited for dumping chemicals into the dirt over the years. The owner of 214 Bryant does not have a permit to operate the type of business in the dirt they are currently operating. All of this filth runs downhill to my property across the street where I have a well. And this is my property for now. It might be somebody else's property in the future. And then it'll be their problem. All I'm asking is that you treat this property with the same as any other property in Ojai and require them to remediate and permit the current operations. I honestly cannot believe that this day and age, 2022, none of you would not care about the environment or protecting the groundwater, the drinking water, from chemicals or pollution. This is going to go way beyond any of us. As far as the next item on the agenda, who are requesting a conditional use permit to have people sit at a restaurant, remember, 214 does not have a permit, a minor CUP or a regular CUP to do the type of business they are currently conducting. Nothing. Therefore, there's no oversight as to what is being poured into the dirt. So if you don't have a permit, nobody's coming to do inspections. Ask for the same treatment if I were the restaurant people, or anybody for that matter. My family and many others in the valley have had to clean their properties and get a sign-off from an environmental firm that the property is clean before any permits were issued. Your credibility is at stake. This is an opportunity for all of you to do the right thing.
Thank you, sir. Sherry, do we have anyone in the waiting room with a hand raised?
No.
Are you, is Susan speaking?
No, I didn't put in a card.
You can speak if you want.
I thought you always ask, are there any other speakers?
I hadn't asked that yet. I was asking if there was anyone that was in the waiting room who wished to speak. Do you?
Yes, I do.
Please come forward.
Susan Francina. I was the mayor when Clough Vista Park was cleaned up and dedicated. I remember all that. up there. Well, mainly what I want to do is express my strong, are you looking at me puzzled? Were you not in Ojai when all that was?
Quite aware of Clough Park and the Shell station that was
Okay.
there before it,
Okay,
yes.
thank you. Just wanted to make sure. I want to express my strong support for the comments made by Chet Hilgers. I agree with, I think it was you that said, Chair Quillisi, groundwater contamination is a public health and safety issue. And I spent the last few weeks looking through stacks of old emails on this, on all the concerns. And I believe there's sufficient concern about contamination of soil and water to continue this item. Thank you.
Is there anyone else present who wishes to speak on this item? Jerry, still no one in the waiting room with a hand raised?
That's correct. No
All right,
one.
then we're going to close the public hearing and come back to the commission for deliberation.
Okay.
Comments?
Yes. In preparation for this evening, I went back and listened to the June 6th and the August 17th meetings. At that time, Mr. William Ulrich spoke from the public, and he said that he thought we were very narrow in our deliberation. It occurs to me that just viewing 10 feet on either side of the line is insufficient to ascertaining whether there are underground tanks on the property. Now, I know you're saying this is just a property line change, so I shouldn't be worried about that. But I am. If this business is operating without license, if this business is operating without fire controls, if this business is creating hazardous waste in our soil, and that can move, that's called perched water, that moves around down there. If there would be a tank, it could be rusting and leaking, or there could just be leftover contamination from the 2 tanks that were removed. I would hope that this would be an opportunity for the city to stand up and do some code enforcement, do some regulation, get a handle on what is right in the middle of our town, a possible bad situation. Mr. Daddy followed Mr. Ulrich, and he pointed out that we have no state water connection, one of the few communities in the state without that. He also pointed out that that means we don't have a backup system. If we contaminate our aquifers, we're just out of luck. So if this is an opportunity for us as a planning commission to make any kind of improvement in this situation by denying or requiring mitigation or getting that CUP in place with a list of conditions, then that's what I'd like to see us do.
I agree with Judy's principles that she's establishing. I'm concerned when I saw this, but I would want to make sure that we have authority to do this. I've raised this question before about conditional, someone having something and they have a conditional use, or they're out of compliance with what a conditional use, and they're now requesting like a lot line adjustment. Does that give us the authority to say, well, maybe they need a conditional use permit now, since they're asking to change their use? And what I've heard so far is, no, we don't have that authority. So my first question would be, maybe we need to be looking at that, as because we have so many old businesses and stuff that, I don't know if that's legitimate or not, but I think it's worth looking into. The same thing about utility lines. And I would have thought we had authority to require a soil test since they're going to be marketing this property, but it doesn't sound like we do. The only way I could see that we could address this, if we really wanted to push that, would be to say that there's such an environmental, obvious environmental issue that the CEQA event exemption doesn't apply. And CEQA could apply, but I don't know that we have sufficient evidence of that. So I'm kind of feel stuck in a way by our regulations and treating everybody the same, but on the other hand, we're kind of ignoring what looks like potentially could be a serious environmental risk.
Jeffrey, can I comment on what you just mentioned? So when we looked at this the first time, the pollution problem was an issue.
Yeah.
So one of the conditions we put in here was the applicant to obtain a Phase 2 study. That was a condition. And then the response is the applicant has not submitted a Phase 2 study.
Our staff basically said we couldn't require that.
We asked for it.
That's true. I mean, we can, I don't know, what does our attorney say?
I mean, the language in the code is that no condition or exaction can be imposed on the approval of a lot line adjustment, except that would be to conform to the city's general plan, zoning regulations, or building laws. So if we were to impose a condition, we'd have to find it in the code itself.
And there's nothing in the code, you haven't searched it top to bottom to find a condition that we could apply that to?
If there's direction of the commission, the city's attorney's office would be happy to take a look. But no, not at the moment.
Can I just speak to the generality of what we're talking about here? We're talking about a lot line adjustment without any sort of development that's being proposed, right? But there's other projects that this commission has seen in the past where there hasn't a lot line adjustment maybe, that has had a project tied to it. And in that category, within that bucket, there are certainly a plethora of other conditions that could be applied for and exacted by this commission. Lot line adjustment is very narrow. It is very narrow. I mean, I'm not going to sit here and lie and say that it's not narrow, that we can go much further than that. But the reality is that it is very narrow for a very specific purpose. And that is to make sure that we're addressing the specific findings that we've talked about, that Mara has talked about as well. I get that this commission wants to go further, but not at the lot line level. If a project does come forward in the future, certainly there's quite a bit more that could be discussed.
The one thing that bothers me about that answer, I mean, when I thought about this as I was listening to previous discussions this afternoon, it seemed to me that if there is a tank somewhere, maybe near Bryant Street on the front lot, it could be years before this lot gets sold and somebody comes in and hopefully requests some studies and that it might be coming back before us. Meanwhile, our groundwater is at risk. So I understand what you're saying, but I'm really troubled by being part of allowing this to go forward if there's any way to slow it down.
So just another inquiry or thought. When we have housing codes, you can go to a current house and say it's below standard. Do we have something like business codes that if they are not meeting the standards, we can inspect them and require them to come up to standard, health and safety, or do some cities have things like that?
There's no ordinances that I'm aware of within this code.
But I meant,
Right.
is this something that cities do? Have like a business code that could apply to them just like we do to housing?
And I mean, housing would be tied specifically to some sort of a known safety concern that's been addressed. And sometimes that's addressed through code compliance.
But I mean, people can go into businesses and burn up or get toxic stuff on them too. I mean, why shouldn't we regulate them in the same fashion?
I can't speak to that specifically.
Okay, so is that something that we could look at?
I mean, I'm not aware of any codes that we have currently in place through our ordinances.
Yeah, I'm just asking future. Look.
Right.
Going back to the fire situation, isn't it a requirement in the code that a commercial building would have a fire extinguishing system?
Like fire extinguishers, or you're talking sprinklers?
Sprinklers.
So that's not a requirement.
It's not a requirement.
Fire department came back and took away the requirement for the sprinklers.
The
That was-
ADU that was contesting this whole subject, a little house, was a big problem because they didn't have a sprinkling system, but we have hazardous waste in the middle of town without a sprinkling system. This makes no sense.
I can't
Sounds like
speak
we got our
the
work to
fire
do in
department,
the
but
future.
You're talking about
code.
two different standards that were
We
being
are.
debated. Yes.
I know. Okay.
Gentlemen, do you have any questions
You want to,
or
Mr.
comments?
Just a comment, it was mentioned during the public communication, or the public comment, that there's a non-permitted business operating there, but what we've heard is there's one business, not two, right?
There's more than one business operating there, and those businesses are permitted. They're permitted uses, meaning that we can't impose a conditional use permit on those uses.
Okay.
And in fact, one of those uses, I believe we put it in the staff report, that has been in operation and received business license from I want to say the 70s, early 70s, yeah.
What would trigger an existing business to require a conditional use permit?
In the use chart, if it identified itself as
So
a
if
CUP,
it
that would be
added
one-
a new
one
building
way.
or-
Hold on, there's another way. There's another way. That would be if the use itself is not identified in the use chart, and then through that, we're finding a similar use that would require a conditional use permit, or imposing the conditional use permit through that process to allow that use within that specific zone.
Yeah. The key is in the zone, if the land use charts say this is a permitted use of the land, then you don't need a CUP because it's already permitted. You still have to get building permits and,
Yeah.
business licenses and all of that, but you don't have to get a CUP.
We want to recognize Bill Wyrick.
Yeah, one more thing.
Before we consider reopening
Yeah,
public comment, I'd like to finish with comments from the commissioners.
Oh, sorry. Do we have something outlining the utilities and potential easements that are here? I didn't see anything.
Not on that map. That's just to show you it's an aerial view of the sites. I also gave you a parcel map with colors on it, color-coded kind of,
Yeah, I
to
see
show
those.
you the 3 different parcels that are talked about, but there's 2 of them that are involved in the lot line adjustment.
Right.
And one of them is a road and utility access, or road and utility easement.
That's the yellow one?
The yellow.
Right. But as far as utilities, no. We wouldn't be showing you utilities on a plan for this
Yeah,
project.
well, just, yeah, the easement.
There's a pole line there, presumably there's underground water lines too, and probably a sewer connection.
On a map that I saw earlier in June, or maybe it was August, the utilities ran next to that road,
Next to the driveway.
next to the driveway on
Pole
the
line
Adamson.
certainly is, yeah.
on
Between the two
Adamson
properties or on the
property.
other property?
No, on Adamson's property.
Well, between the current parcel B and the unnamed parcel.
Yeah, the paved.
May I ask a question? At the end of the last meeting, there was going to be a new map drawn which avoided the building. The new maps that we have here today, do they have the adjustment for the location of the building that was?
I'm sorry, I'm not sure I understand.
At the end of the end of the last meeting, there was some uncertainty, and there was posited by someone that the building currently sat upon the lot line, that a
Yes.
building sat upon the lot
it
line,
does,
and it was to be adjusted subsequent to the meeting. Right, and the question is, does this document show the adjusted line or not?
The document in your hand does not show the adjusted line. That's the existing, those are the existing parcels.
Right,
So
This one does.
and this one,
and that's just an aerial view.
well, it's got lines. in it.
That does have lines on it, however,
It has,
This shows the old lot line.
right, okay. It has an arrow and a line. and it
the
says
proposed lot line in red is on the aerial view.
That's the adjusted lot line?
Yes, proposed line is the adjusted lot line.
Corresponds with this.
Right.
And the existing line, I believe, is in yellow over here, which straddles the existing building written in red.
Fire utility.
We're done? John?
Yeah, I'm good. Thanks.
Okay. Recognizing the impossibility of proving a negative, namely that there are no tanks under this proposed lot line, I find myself frustrated. I am also concerned that if we reach a point where a lot line, the proposed lot line is approved, and then a sale of the front property, I think it's called parcel A in the new wave, that any contamination in parcel A becomes legally not a problem for the city, but only a problem, potential problem, in a dispute between two private parcel owners. But it is still a problem for contamination of the groundwater if it exists. And I don't know what to do about that. 10311 says if you're looking for a lot line adjustment, what's under the ground is not in your purview. That's the way I read 10311. And as Lucas knows, there are lots of things in Title 10 that I don't particularly care for, but I have to enforce them because that's my job as a planning commissioner. So, with the permission of the rest of the commission, would we reopen the public discussion here for a moment? Mr. Wyrick, please come forward.
You're either blessed or cursed with two council people here tonight. that We've been chatting.
We're trying to decide which of those it is.
I know. I'd like to answer your question with a possible solution that is fair to the applicant. And that would be, would it be possible with the appropriate approvals, it might require it might be within a budget discretion of the city manager, I don't know. Since there is a public purpose concern, a public welfare concern associated with the groundwater contamination, but that it could only be resolved through soil sampling. I'm trying to answer your question, Chair. And in terms of, since to clear up the issue of, is you proving the negative or proving the positive, would it be possible for the lot line adjustment to be conditional on the property owner allowing access for the city to pay for soil sampling to understand the situation? I don't think it's fair necessarily to put an undue burden on the applicant, but given this public concern, that giving this overall groundwater quality concern, I would ask the question whether, through the chair, perhaps to staff, of whether that is an option for the city to step up and ask to simply be given permission for access to do a soil sampling investigation.
Are you also thinking in terms of a geophysical examination of Lot A?
Yeah, I think that's another thing that the city could simply say, you know, we understand it's maybe not appropriate to put this burden on the applicant. Let's be fair here. But there's certainly a matter of some public interest here.
Yes.
And I don't know the answer to what the procedures might be for that, even though I'm on the city council. But I just think in terms of fairness and public interest, you don't want to put all the burden on the applicant when it's not appropriate. But on the other hand, there's certainly something we want to find out here. And is that an option? And I guess it's kind of a question for staff through the chair.
I think it's a question for staff. I don't have any idea what the possibilities are there. At the same time, and while I want to be fair to this applicant, whom I have known for some years, and so that's makes me a little queasy about all of this. If it were some person I did not know, and I said, you know, if there's a problem there that none of us have located, and you basically redefine the boundaries of what you're responsible for, sell off the property that you wish not to be responsible for, and it becomes someone else's public safety problem, where's the city's interest in that? That's one of those things that I cannot find a basis in the municipal code for us doing anything about, but it disturbs me greatly.
I was just going to add, looking at page.
Wait, let Lucas.
Well, I was going to
address this.
respond to that.
I thought you were leaning forward to speak, sir.
I was, but it looks like there's an additional pieces
Well, I
to
think
this, and I'll
we
respond.
had public comment open, I believe.
Oh, yes, I think we should,
Whoever wanted to speak.
Oh, we got another public comment.
as long as it's open.
Yeah.
As long as we're open. So I just want to challenge Lucas, because you said that everything is permitted, all the activity on that property. And I don't care where you put the lot line. I don't care what they do with their property, as long as it's permitted, because I being downhill, I don't want all that crap washing down to me, which it does. And it goes right down past the Wheel Tennis Academy in that drainage ditch. So a towing business, impound yard, auto dismantling, those aren't even listed on the use chart, let alone a CUP. So I would challenge you on that, if you want to look that up right now while I stand here. It's kind of like Jeopardy.
What were the three things
I'm
you
not
said?
looking it up right now,
Towing?
but yes, I will look it up.
But I already got an email from the clerk. It says it's not allowed. So
Towing, what were the other two?
towing, impound yard, auto dismantling.
Yeah, I believe it was permitted for time.
Impound means just
I
someplace
think
you store
auto
cars.
service,
For the
I think
CHP?
auto service, major and minor are permitted uses.
That's up in the building, my understanding. But
It's-
everything in the
it's
dirt
on-
lot,
It's in that zone.
everything in the dirt lot, Steve, it's Adamson's Towing. There's no permit, there's no CUP for a towing business. Just get it permitted, that's all I'm saying. Just get it permitted, go through the process like everybody else, and have it clean.
Back to the land use charts. And I think we will again
And
close
auto-
the time for public comment.
Auto something,
I think
repair,
Jeffrey had a
I guess.
comment.
Oh, dismantling.
Jeffrey, you had a comment?
Oh, I was just, because you raised that question, so I would need to hear from the attorney, I guess, what this means. Two things. One is, I think we ought to be looking at that CEQA exemption as to what the case law says is actually a serious environmental condition that would prompt us not to get an exemption, number one. I don't know what that is. I just read the statute, but so I hadn't had time to look at case law on that. The second one, though, it says right here, no condition or exaction may be imposed on the approval of the lot line adjustment. So I would assume that that is a problem from what is being proposed, unless the applicant is, I'm not even sure, volunteering to do something more at the request of the commission might also be considered a exaction. But anyway, I'd like to hear your legal view of that.
Sure. I don't think if the applicant accepts it voluntarily that it's
Okay.
we're imposing it. So I think that would be acceptable. As for the question,
Imposing what now?
sorry, a condition.
The condition of
That
having
was
them
proposed by-
to let the city go on their property and to do this analysis. That would be an exaction if we
Do we have
required
any
it.
idea what a phase 2 for this size property would cost?
Well, you'd only need the front property.
The front property we're talking about.
I don't know. Well, how do we determine that? We only need an analysis of the front property.
The back property is not up for sale. It's the front property that is at potential here for more development.
And what happens if there's substantial,
If the back property is eventually sold?
Then they'll have to deal with that at the time.
what would be the result? This is just speculating here. If we did this phase 2 study and we found substantial mitigation had to happen, who would pay for that?
I think that's where staff's concern lies, and that is a private matter, not a public matter.
Well, that's where I started with my original question. If there's a public safety question here, what is the planning commission's role or ability to be concerned about that? It sounds, certainly from 10.3.11, we have no play in that at all.
And that's where
What we're doing is moving a line on the ground.
Right, and I think it's important. Look, I recognize that this commission and the community certainly are taking the blinders off or wanting to take the blinders off regarding what the lot line adjustment has and what this commission has in terms of the findings specifically as it applies. Beyond that, like I was saying before, there's really kind of two different boxes. There's just a lot line adjustment, which is what's being requested here by the applicant. And there's a lot line adjustment that could be tied to a bigger project or a potential use or something along those lines. That's a different box than what we're looking at here. Here, we're only looking at those 4 specific findings. I recognize there's concerns by this body and certainly the community, but those pieces are more private matter than they are as it exists within the lot line adjustment and Title 10.3.11.
And there's nowhere else in the code that allows the planning commission to be concerned about underground contamination. I mean, if that's, I don't want to get too
Granular.
all-inclusive in making a statement like that, but if that is the case, then we shouldn't have come to where we are now with a Phase 1 study, for that matter.
The phase
Phase
one was
1
requested.
did apply, yeah.
The phase 1 was requested, and at the
Well, a
meeting
Phase
in-
2 was requested too, but it wasn't done. So,
Well, in lieu of that, there was the geo something, the study that was done subterranean. That was done as an alternative. Here's the situation. In July, we were aware of a phase 1, but we weren't sure when it had been done. It had been done back in 2019, been done for quite some time. So that was new information, right? Typically not done for a lot line adjustment, but the applicant had already, well.
but it was
The applicant,
relevant
as
to
well
the
as
two
our
lots.
representative had that done. Correct.
Yeah.
So it was information they were willingly able to put forward.
I think I was misconstrued what our potential authority was when we asked for that phase two, because I kind of thought we could have some authority over if a property's going to be marketed as a result of this lot line, that we ought to, for a
Like, we
public,
don't have that authority.
for a public health reason, we should be able to do it. Apparently, we don't have that authority. And, well, we don't have it. Could we have it? I don't know. That's an interesting legal question, but anyway.
Without a change to the code, I think not.
Well, and you'll have it.
Attorney's shaking his head no.
When there's a development proposed on either of the parcels, that'll be a time that it'll be required. And it will be your purview to request it and to review it.
Right?
That could be years.
Well, yes, and the time that elapses is a separate question for me, at least. What I am concerned about is that there is a business here that has certainly the potential of having contaminated the ground. And if part of that ground is sold off, then it becomes somebody else's problem, you're saying.
Private problem, until they want to do something
Okay.
public.
If I were a private party thinking about buying the front parcel, I guess I would start asking a lot of questions.
That's what the last buyer did.
Yeah. I don't know if we got the answers to those questions or not. But it sounds to me like, by the code, much as I am concerned that we're not doing enough, I don't see that we have the purview to question a lot line adjustment that otherwise meets all of the provisions of the code. Is that a fair statement? I don't like making the statement, but that's what it sounds like to me.
It is meeting, the way in which this is being presented to this
The
body.
lot line
It's
adjustment
a lot line
itself
adjustment only.
conforms to the code.
Correct. And that's all that's
And-
being
and-
proposed.
And we do not have the purview to deal with other matters underground.
We need to look at our code.
Correct.
obviously.
Not
This
through a
is
lot line
authority
adjustment.
on these.
So
Less authority on architecture, more.
I wanted to also speak to the use piece that was brought up. It falls into the same category, but I'll respond to this as well. Uses that have been on site for several years, ongoing uses. If the code changes over time, like let's say for instance it was a permitted use, granted a business license in the 70s, 60s, 50s, has been maintained on site for however many years. And the code then adjusts itself, either no longer allowing that use to be maintained or requires a conditional use permit. The city cannot exact a conditional use permit or identify that use as not being allowed anymore unless by the code that use stops being in use for a certain amount of time. I believe it's 180 days. And then we can start exacting what the
Then
current
it's a
standards of the
new,
codes
then
are.
it's a new ask
Correct.
and a new and asking under a new set of rules.
Right.
Yeah.
So if some business was polluting the land or the water, and it was going off-site to some other property or to the public right-of-way or whatever, what would be the authority to intervene and have them correct that pollution?
If it was brought to the city's attention, we could have environmental services take a look at it, and that's
I
something
see,
that's.
and they have authority to
They have a blanket
force people to
authority.
mitigate that kind of circumstances.
This is the County Environmental Health Division, you mean?
Correct.
Okay.
Okay.
And we've had that done on other sites where it's been known, and that's been handled through code
So
compliance.
Mr. Helgers could go to them and ask them to look at this.
We could do
The
that.
first step
We
may,
could if we thought
We
there
could
was,
direct
first-
staff to do that.
well, the first step may be actually code compliance.
would be what?
Code compliance.
I see.
What part of the code applies?
Code compliance handles situations slightly different. Still making sure compliance with the code. So if there is a ask or request or a potential violation that's being made known, granted, we're not going out and looking for these things. We are complaint driven.
Good.
Yeah.
So any neighboring property owner could go to the code and ask them to look at this. Is that correct?
we would need more information than just simply saying, hey, take a look
Well,
at
if
it.
they had some evidence of something. they
That would
could.
probably be helpful, yes.
I see, okay. Mr. Chair, do you want to ask the applicant, as Mr. Wyrick has suggested, whether they want to voluntarily allow the city to go on their property and do an environmental?
Whether the city
Study?
chooses to spend that money or not, I know the planning commission has
We have no authority to do
zero
it.
budget for anything. Sure.
I just want to say one thing, based on that. Any one of you are welcome to come down to the property and see how well kept it is. There is no oil and stuff being poured into the ground, running across the street into the drains that I've ever seen. We've done our best to keep that clean for years. As far as permits, we have permits for everything that's there.
The question here was, would you object to having the city come and do additional tests of the ground in either parcel?
Within reason, it'd be fine. I'd like to know some more about it. I mean,
I don't even know if the city wants to spend the money to do that.
Yeah, my only concern is more than likely that would be something that would be, this body doesn't have the authority to exact funds. It would be through
No.
city council.
Right.
And that'd be between
Public interest.
us and the buyer, as far as I'm concerned.
Yeah.
And we're here for a lot line adjustment. It seems like we're going back and just digging at things that happened in the past instead of focusing on now, which gets a little tiring, to be honest with you.
Yeah.
And for your information on the fire system, when we did the reconstruction, at that time, they were told they had to be put up. Okay, and then time went on, and I spoke to the fire marshal, and he says, Glenn, there's nothing there that says you have to put that in that building. So I wasted all that money for that for no reason.
Putting it up and taking it down.
Yes. And I think you have her card from the fire marshal. So, and it seems like we keep pedaling backwards and just digging up dirt on everything instead of getting something done. You know, and I'll answer any questions you want. But that is a clean facility, and I welcome you, Mrs. Murphy, to go by there and check it out. Anytime you want, any of you. So, like I said, I just want a simple lot line adjustment. That's all I'm asking for. I'm not asking for the history of the shop, the property. You know, there could be Indians underneath the ground out there, I don't know.
Oh, they'd be in trouble then.
Yeah.
There are different provisions for that already in the code.
Oh, you know, where do you start and stop here? You know?
Okay.
So I appreciate you looking into it real seriously.
You don't mind the city coming onto the property, though, to make tests?
I do not.
Very good. I thank
Do
you
not.
for that, sir.
Sure, and I'm sure Lucas, you'll be the one that'll
That's-
tell me, huh?
That's a separate city decision, and it's not a planning commission decision.
And we should not put it in the ordinance, because it's not really.
I would just like to to move forward, Steve. It's just been going on and on and on.
Sure.
You can understand where we're at.
Of course.
And I appreciate Mr. Wyrick too, his comments, and he's right. So, okay?
Thank you.
Thank you, guys.
Thank you.
Mr. Chairman,
Well, I'm
it's-
exhausted. How about you?
Well, let me point out that at one point there were 21 gas stations in Ojai. This is a ubiquitous problem. It's, you know, how we solve this, I think, is really, we need to look to the future. We obviously have something that's before us right now, which is a lot line adjustment, which I don't believe, based upon my reading of this, gives us the authority to snoop around and try and find something that'll stop the project. I wish there were, because I do concern myself about groundwater and the seepage of petrochemicals into that, but you know, that's all over this territory.
And I'm concerned about the city's liability if there is a problem there. But I think the city attorney answered that, at least within the bounds of anybody can sue anybody anytime for anything.
He's promised to pay the legal fees if it
There is a hold
happens.
harmless provision in there, so.
I will just jump in there and say if the planning commission feels that the indemnification provision should be upgraded or beefed up in any way, we're happy.
Wouldn't know how to do that, sir.
Sounds good.
It's a standard thing that I think has, at least so far, seemed to serve the city well.
Correct.
With all of that said, a motion one way or another on this case is now in order. Anyone care to make a motion to either approve or disapprove item 2?
Nobody wants to be on the spot.
Well, for discussion purposes, then,
Yeah.
I'll make a motion and see if we get a second. I move that we approve item 2. Is there a second on that?
I'll make a second based on taking these things and separating them and looking them at pieces. This is one piece. This is just a line on a map.
For discussion purposes.
Yes, for discussion purposes.
Discussion of the motion?
I wish there were a way that we could try to protect the city and future users of this property by having a study done on the soils. I just don't think we should be marketing properties that there's questions about their, or letting other people market them. I do think it's a public responsibility to some degree, but we don't have our statutes, appears to me, written in that way. So as much as I would like us to explore this further, I don't know that legally we're justified in doing that.
If this is just the one bucket, that it's the lot line, I have no trouble or problem with the lot line in and of itself being changed. I mean, that, in fact, it would be a good thing to do. I guess I've already made myself clear about my concerns about the water and the fire and all of those other issues. And it sounds like we just have to wait until that property has a buyer and a project that'll come before us before we can do anything with it, which I find very unfortunate, but that's reality.
Yeah, that's my conclusion. We're enforcing an incomplete municipal code from my point of view. But I don't see that we have the ability to do more than that. I'm wondering, City Attorney, would it be legal even to put a condition on this lot line adjustment to say that the current owner of both parcels is responsible for underground contamination if it exists after the lot line adjustment for both parcels? Is that legal? It sounds to me like probably not, but I don't know. That's why I'd like to understand that one.
I'm slightly worried there because it's assuming an environmental concern.
I'm
But
saying if the condition existed, could the current owner of parcel A, we'll call it, I think that's what the front's called,
Correct.
could the current owner of parcel A be held responsible for contamination on parcel A after it is sold to another party?
Could we impose that condition, or
Could we impose that condition?
I'm worried about for two issues. One is the language in the municipal code, which I think is
I recognize this is separate from the lot line adjustment per se.
right. I think we could probably put it in. I don't know how a court would treat it. I think they might view it possibly skeptically. That's what the kind of the
Well, I'm
indemnification
kind of skeptical
clause.
about it myself. I'm just asking.
Yeah. So I think this is my.
The other problem,
on
it
it.
seems to me, is what kind of a precedent would that set? Would he have to have that condition on every time we approve
Yeah,
anything like that? And I'm not sure
It doesn't
kind
feel
of getting
right.
us into the
Feel right.
private people's business sort of thing.
I mean,
Okay.
isn't there an argument to say the best thing that would happen is there's a transaction for the sale of this property and somebody buys it and develops it and has to go through the process?
Yes.
Because otherwise it's gonna sit there and potentially be a continuing problem of possible leakage.
And a non-performing asset for the city and a potential
Right.
ecological problem.
But we have the clause that indemnifies the city, so if there is contamination on the other property and they sell it, so there's gonna be litigation between those two properties. And that,
May well be.
they've indemnified us from being involved with it.
John, your thoughts?
I mean, like I said, I think that, if we look at this thing and we're separating them by the bucket, this is a simple lot line adjustment. The other environmental issues, the other issues permitting, all that other stuff, that's separate from this. Those are additional conversations. This isn't about that. We don't necessarily have the wherewithal within our code to impose any of that. So I think we just have to look at it.
What I was suggesting kind of falls into the category of imposing environmental conditions on a piece of property before it's sold.
Right.
I'm not comfortable with it, but I don't know if that's an answer.
Right. I think just to kind of jump in here, as I see it, there's possibly, if the lot line were to be approved either tonight or at another planning commission meeting, there's, multiple features for the property, but, some of them are the property gets sold with, first of all, the property gets sold, with no lot line adjustments.
Either piece.
Right.
Yeah.
Or, the lot line's approved and one parcel gets sold or both parcels get sold. And then there's, so that's, the new buyer could potentially sue for environmental contamination, but it wouldn't be based on the lot line adjustment if they bought it with or without a lot line adjustment, most likely, because that wasn't what caused the contamination. If there were a new buyer and the new buyer were to try to develop something, then they'd have to go, come back before the planning commission and go back through the process. And then if they found out then that there were environmental contamination, then, the lawyers might be fully employed for a while. But again, I don't think that, depending on if they bought one property or both properties, what they're worried about is the environmental contamination, not that the lot line adjustment was done improperly or that, or that it affected the contamination itself.
Okay, and as I read this Rincon report, and it talks about providing an opinion as to the presence of recognized environmental conditions, RECs. And as I read through it, I could not see clearly that there was something. Is that the staff's conclusion as well? Okay. I am frustrated by this because I don't think we have the authority to do what I'd like to see done. And therefore, I'd like to call the question. We have a motion on the table to approve item 2. Sherry, call the roll, please.
Chair,
Yes.
Bennett,
Yes.
Trent,
Yes.
Murphy,
Reluctant, yes.
Very reluctant, yes.
Starkweather,
Reluctant, yes.
Okay. You have your lot line adjustment, sir.
Now, staff, could we, at some future point, be looking at, it does disturb me that potentially there are businesses operating that are having pollution across boundary lines. And it seems like when we have a existing business that doesn't have a conditional use permit, but then wants to make changes, that seems like a good time to make sure that we're not allowed to do it now, but we could be looking at somehow getting that authority. Not extreme requirements on people, but, I don't think it would have been unreasonable in this case to do a Phase 2 study before we approved it.
Again, a phase two study at city expense
Tried that.
is.
I know, they
is
won't let us do it. I'm just saying,
non-negotiable.
can we look at whether we can, down the road, maybe get a little more authority or get a little better way to get a handle on businesses that are
Perhaps I
currently
could-
below standard?
Perhaps I could suggest a compromise here. Since this Phase 1 study, having been provided to the city and to the Planning Commission, is now a public document, could we ask staff to contact the County Environmental Health Division, provide them this Phase 1 study, and ask if the Environmental Health Division sees a reason to do anything more looking at this property? Is that the kind of thing we do, or is it the kind of thing we could do, or is it the kind of thing we shouldn't do because there's something in the code?
So I would probably prefer that it go under the umbrella of code compliance. By doing that, then
But where in the code does it say ground contamination?
we begin to look at it beyond
It's
the lot line.
outside of Title 10, for
It-
sure.
Yeah, it's beyond the lot line adjustment. It becomes,
Yeah.
in some cases, a safety piece as well.
So do we, when you say
Code
code
compli-
compliance, that's just the body that actually carries out the code. Now, we're talking about whether the code itself is giving us authority
Well,
to actually.
that's a second question, and right now, we don't have the authority.
But I meant giving
You do have your
even the
lot
code
line
authority.
adjustment plan.
Right, we can, look, I don't want to get into that's not necessarily something that's on the agenda.
Okay.
Moving on to the next item, but I think code compliance is probably the best starting point.
And
for
does that
this.
start with you, or does that start with perhaps a neighboring property who's concerned, or who activates code compliance?
It can be done through staff or through an anonymous individual.
Anonymous, has to be anonymous?
Typically, they are anonymous. Not
Well,
typically.
I don't
they
think
are
that-
anonymous.
Would
This one is
would
very
staff do
anonymous.
it?
I don't want to get into the details of it right now, simply because it's not on the agenda for discussion. And code compliance typically isn't, but that would be in my opinion, the next step.
Fair, okay.
Okay, code compliance.
We do.
I think as citizens, we can do that. All right, well, let's move on to item 3 then. A director's exemption and minor CUP at 314 El Paseo Road. Maura?
Thank you, Chair Quillisi and Commissioners.
We gave it our-
As I give you my presentation, I'd like to pass along a structural report that was provided to me this morning, just for your information. So the project was, sorry, is that okay? Okay.
But if we're going to do that, copies to provide up.
How about,
Let's pass one copy back to Maura, and she'll put one in the lobby.
Oh, I see.
Yes. What we're doing? Just a couple, 3 sheets stapled together?
Yeah. If there's not enough, then how many is there left? There's enough.
That's
Oh, that's
just
great.
enough.
Mackerel.
My magnifying glass. Oh, my God, that is small. Did you bring us a magnifying glass? Most of us are over 50.
Soon to be. Soon to be.
I can't read that.
I can't either.
This is on, huh?
it's
I
on.
just want to say thank you all very much for listening to everything, and I know it's hard, but for approving our lot line. It'll simply make things a lot easier, and we can move forward.
Well, you can see we're doing the best job we can.
You are. and I
Appreciate your patience.
Each and every one of you this evening, I do. Means a lot. Okay? Thank you very much.
Thank you. Oh, my God.
So
this is-
thank you again, and sorry for starting off with a surprise document. This project was initially a request for director's exemption and a minor conditional use permit for a permanent outdoor dining facility to accommodate approximately 20 patrons on a porch adjacent to El Paseo Road on private property associated with Nocciola Restaurant located at 314 El Paseo Road. The outdoor dining was previously temporarily approved during COVID indoor dining restrictions. On August 3rd, the Planning Commission reviewed and considered the request for approval of permanent outdoor dining on the patio or porch that I just described. And at the time, the applicant learned that the existing outdoor dining area requires extensive structural improvements in order to receive a building permit. Therefore, the applicant was and continues to work with the property owner and architect and engineer to determine what their next steps are. So this morning, the applicant provided me with these structural plans, basically to show that they're working on the project and not sitting stagnant with it. But however, they're not prepared to move forward at this time. And so staff is recommending that the Planning Commission continue the application for the director's exemption and the minor conditional use permit to a date uncertain, because we don't know when the applicant will be prepared and submitting plans for us to review. And in the meantime, the applicant has stated that the outdoor dining has now ceased, and the outdoor dining on this porch approved as temporary during the COVID restriction is no longer permitted until a formal request has been submitted for approval by the Planning Commission. Yes, and the director wants to add a couple things.
Sorry, I'd ask permission. I also wanted to chime in here and just identify, we've met with the applicant on a couple different occasions to try to iron some of this out. We thought we had solutions, but it's funny how once you start going down a rabbit hole in terms of a structure that was built and then never ended up getting permitted, but it was because of COVID, and we were looking at just finding ways to keep businesses open, that it's actually created a bigger problem, which is now becoming a safety issue, meaning that the structure itself is not structurally sound in its current state.
Okay, so when this structure was originally allowed, I hesitate to say permitted because you say it didn't have a permit.
Yeah. Was
When
never
the
permitted.
when the construction was allowed, were there any city standards applied to that construction?
Zero. There were zero city standards that were applied. Well, I can't say zero. There was 1% of the standards that were applied, which was the temporary outdoor use permit, simply to have outdoor dining.
But
How that structure was
in terms of the
built,
construction
had
of the
absolutely
facility, nothing.
nothing was permitted.
So how did we allow someone to build a structure without any?
Because we were in an unprecedented situation at that time. Finding solutions, realizing that they were temporary solutions, and trying to figure out if those could be permanent solutions. Being on site and being on that structure felt like it was a sound structure. However, having professional licensed individuals out there taking a look at and assessing the situation, they realized very quickly that it is not a sound structure, that it is not a safe structure long term.
So the city building official had no part in
No.
looking at the construction of this.
So they've condemned it, I take it at this point?
I don't know what to say. I guess you could, I don't want to say condemned. Condemned's not the right word. I think identify that it is not structurally sound for permanent use.
But they can't use it now. Can they use it now?
No.
Okay.
No. Now that it's been
now-
identified,
It's now, well.
it cannot be continued.
So
That's the-
closed, I mean, they can't even go out that
This
door?
is not from the city.
Because parts of it were not
Private
in the
party.
structure.
Could have fooled.
Because there was the structure in the front part, but there's outdoor eating facilities like going out the same door, but they're not under that structure.
Yeah.
Yeah, so it's the rectangular structure that is,
So they
To
just
the
they blocked it
south.
off?
it's not being used.
It will be closed off to prevent guests and patrons access.
Right.
Okay.
Now, what you're seeing before you is the business owner doing their due diligence and actively trying to find a way to get a permanent structure out there.
They're saying this is what would have to be done if we were to upgrade the structure to be
Compliant.
okay with, compliant with current code as a permanent structure.
Right.
And they have not yet decided whether to do that?
They are indecisive at this point.
So they're indecisive whether they would try to repair this structure or to put a whole
That
new
you
one
can't
or do
repair the-
nothing.
It's been identified that you can't repair this structure. It's
So
gotta
why
be
don't we
removed.
require them to tear it down?
It will have to be removed.
Oh, okay.
Now, what they anticipate doing, and they're still working through this right now, is using as much of that structure as possible as they look at finding a safe and code compliant, building code compliant structure. Yeah, and right, materials for that.
Let's just hope someone doesn't walk through there and the thing collapse on them.
Yeah, so there's a couple. I mean, there's several issues that the professionals have identified. These licensed professionals have identified, engineers and architects. 30 seconds out there, they were identifying there were several issues. So
So some of the components of the construction may be usable in reconstruction to current code, but there's more to be done, it sounds like.
correct,
And the cost may be such that the owner decides not to do it, yeah.
potentially.
Do you need a move to continue the item to a date uncertain?
Yeah.
Staff's
That's what
requesting
the
it be continued
staff is
off calendar.
asking for.
That's-
Allow staff to work with the business owner, who is also working with the property owner, they're all working with a licensed professional to get this addressed.
Okay, that's what I'll move.
Well, we do have public comment. We have a hand raised,
Yeah, public comment.
the tenant.
Okay, we're finished with questions for staff then? All right. Is this this says it's a discussion item, so it's not a public hearing, but we can have public comment on a discussion item.
So the
So
applicant tenant
let's
is
open the
on.
meeting for public comment. I see a
Can you hear me?
Jessica Trent, please go ahead, ma'am.
Can you hear?
Oh, different person.
It's the
Hand raised.
applicant, Pietro Biondi.
Yes, that's me. Good evening.
Ah,
Hi,
okay,
sorry,
we
I
have
was-
the applicant
yeah.
here, good. Please
Yeah,
go
I'm
ahead,
on
sir.
call, sorry. Okay, I was listening to, I believe, Lucas about the structure not being sound.
Are you there?
Can you hear me?
Yes,
Didn't understand you,
Okay.
though.
go ahead.
So, I never had any professional that said that the structure is not sound. The engineer that I met with mentioned that he wasn't able to work plans based on my work because he say I'm not gonna put my my license number, my license losing my license on a building that you built. So now, Lucas, did you hear some professionals say that the structure is not sound?
I heard that directly from you in a meeting that we had a few weeks ago.
What I've said that is that he said that there is some regulation, just a few. One is that any structure is either built on concrete or it is built with at least 18 inches crawl space. So the structure doesn't meet any of these requirements. But I never mentioned, I said it's unsafe. It doesn't meet by codes. So he has some violation, but I never mentioned when we met that my structure is unsafe. I
So I have
explained to you the reason.
I have a question for you
Yeah.
then.
Yeah.
Is the structure allowed to be as is currently?
Well, that's why the meeting is upon. It's not. It wasn't decided by anyone. What I'm saying, that's why the meeting. That's why we are talking now. But about deciding on the structure, as a good faith, we had the meeting. I explained that he said that what he could see, there was a couple of things. There was a violation on building code, which is the structure in some area doesn't have 18 inches clearance, and in other areas it's not built on concrete. But he never said, and I never said that the structure is unsafe and unsound.
Okay.
So that's what I want to say. Okay,
So
that's what I
it's,
had my meeting with.
non-conforming at the moment,
Yeah, there
and
is,
as a new structure, it can't be non-conforming.
standing on it, as you said that. Okay, so that's why now I'm trying my best to work and to work and try to find a solution. As I said, I am not in a position as the city has zero budget, my company has zero budget. The property owner, unfortunately, logistically, it's a little hard to get in touch with them and meet with them to see. I thought they were on board to help us doing it. Now I feel like that maybe they're not. What we're asking now is just for to keep the structure without using it, so it's a compromise. I will close access to the structure, the 2 points of access. I will block them, so nobody can stand on the structure. I'm not gonna go now to the effort of demolishing, because in case we do the project based on those plans, we can recycle some material. If I demolish now, the material would be a waste. And as I mentioned before, I spent closer to $80,000 to build a structure, which is not unsound or unsafe. It just has some violation. As I mentioned to you in the last meeting 3 months ago, as I mentioned, I am not willing to tear down the structure and pay for it when maybe there's a solution. You were saying during the meeting that, it might be some minor repair or fix. I was certain there was a tear down. So, now I'm just asking to wait before I spend money and see if we can, do the project and recycle most of the material. Otherwise, it will be a complete waste. But the structure, even if it stands, it will be there for 2 centuries. It's not going to go anywhere.
Okay, it's not a request from staff that we do
I heard that
anything
you
or
were saying
direct
that
anything with regard to the structure, simply
Before I
that
raised
we
my hand,
continue
you were
the
talking
case.
you were talking about demolishing it because it was unsafe for people walking by.
Okay.
That's something that I never mentioned this to be unsafe or not sound.
Okay,
Never.
okay.
And,
But it-
and no professional said that.
Okay.
Sorry, Lucas. Well, I want to make sure I clarify what the
Just-
professional people told me. Yeah.
All right, just to clarify, sir, it's your intention not to use the structure for dining purposes until you decide either to upgrade it to current code or you decide never to use it. Is that right?
Pretty much, yes. It's
Okay.
I'm not. I can ask you now, the commission, to allow me to use it for another 3 months, but
No.
I don't feel like push my luck. I know what I did when I built it. As I know that the city itself knew what I was doing. Nobody stopped me. Everybody kind of turned a blind eyes on me. Of course, you were trying to help me. I don't blame the city and everybody involved. Everybody knew it. It was in everybody's face what I was doing. It's my bad. I acted, tried to save my company, and keep my employees on board.
Sure.
Now, because of this, from this week, I will lose about 40% of my revenues. That will be a domino effect, also my employees. Because of the structure, which I built to save their job, now because of this, of tonight's meeting, I don't know if I guarantee the job for those people. You understand? I want to just put my point there. And everybody knew it. The entire city saw me for about two months, 60 days building.
Yep.
You came to dinner too, some of you.
We came
And
to
now,
dinner.
now it's unsafe, it's unsound, tear it down.
I've ever eaten there.
I didn't do it at the moment thinking I'm going to keep it. Yes, of course, but it wasn't the point. The point was trying to have outdoor seating to save my company and keep my employees employed.
Okay.
And the city knew it. Now, that's a property owner argument. It's not my argument.
Okay, thank you, sir.
So
When this-
legally, we are both kind of fault here, not just me. Nobody's not me. You guys know, Lucas, everybody involved. I sent plan. You approved plans. The city approved those plans. was temporary, but you approved it. I could have put tables on the middle of the road and nobody would have said a word back 2.5 years ago.
Yeah.
For 2.5 years, you let me use an unsafe, now it's unsafe structure with thousands of people that been on it. And now from today, it's unsafe. That's what I'm trying, that's my point.
I'm willing to concede that the structure is not unsafe.
Yeah, I consider as well that the city knew what
Very
I was
good.
doing.
Very
and
good.
You turned a blind eye to me.
Do we have any questions?
And it was in good faith from you, from the city and from me.
Sure.
Everything happened on good faith.
Very good. Very good, sir. Thank you.
Let's keep it that way, yeah. Thank you.
Do we have any questions for the applicant?
Nope.
No.
Okay.
We have a motion on
That-
the floor.
Yeah, that motion shouldn't have come yet.
You gotta
because
remake
We
it.
haven't been through all the rest of it. Great. Thank you very much, sir.
Thank you.
Sherry, do we have anyone in the waiting room with a hand raised who wishes to speak on this item?
No.
All right. Then we're going to close the period of public comment, come back to the commission for deliberation and a potential motion.
Now?
Now.
I move to continue the item to a date uncertain.
I will second that.
Very good. Any discussion?
And we're leaving it up to the community development director to enforce not using this.
Code compliance works for you? Okay.
Okay.
Then that would be a yes.
Yes, okay.
All right. Any other discussion? All right. Sherry, would you call the roll, please, on item 3?
Quillisi,
Yes.
Bennett,
Yes.
Trent,
Yes.
Murphy.
Yes.
Starkweather.
Yes.
Great. Let's move on. Item 4, priorities of Planning Commission and Community Development Department. It's really nice to see the list a little bit shorter.
Really? It looks the same to me as last time.
No, no, that VMU stuff is gone.
VMU is
That's
as
gone,
off
okay.
to city council. Now, the unfortunate thing is that it won't be before election, but we're looking for it in early January. That's really when we're looking for it. So maybe sooner.
Not my problem.
No,
he
they
said.
canceled the meeting, so they can't do it.
So that's that item. I just wanted to give the commission an update on formula business as well as, and also, I believe this is the appropriate time, and I'll check with the attorney. Our ad hocs, we have 2 ad hocs that I think we created that were created through this, as if I recall correctly, right?
During our last consideration of this list.
Right, which was through for housing as well as parking.
That's correct.
I'm not saying that it happens today, but for future meetings, just know that this is the item and certainly the time in which those ad hocs, and I'll add something at the end of this as well regarding the ad hocs in the future.
And we will be ready to meet and
I don't want to
report
spring it on you
by next time.
tonight.
After the election.
After the election, yes.
2 weeks
Some of us
from
are a
now.
little busy.
Understood. But I just want to know that this really is the platform for that moving forward.
Yes,
So-
and we
Did
want
you
to
say
do that.
Formula business is rising to the top?
Yes, we've been working on it, and we are getting geared up for it. I anticipate that'll be in the next coming months. We have a hard date. I want to say it's in August, and we want to try to beat that date and try to get this resolved before then, way before then.
Well, August is the end of the current moratorium.
Right. We can't extend it any.
I think we
any
should
further
just
after
wait
that.
the last day, this like we did last time.
Prefer not to do that. I don't know. Most of the commissioners were on when I said, when we had mentioned that, it's a year from now. And I said, that year will show up quicker than you know. And it did.
We're first on the board
But-
and we have to make a decision
Well,
about
and
something.
and it's not our decision, it's our recommendation.
That's, well, we had to
the
make a
city council
recommendation for the
decision.
next meeting.
Exactly. So we've got to make sure we're following that process.
Okay.
So that was the one that we're working on currently. General plan update, and the affordable housing. I'm actually meeting with the the consultant for the for the housing element, not just affordable housing, but the housing element, to get that hopefully resolved, and then to city council and then off to HCD.
Your annual performance report?
No, that's separate, and we're working. That's the APR. That's the annual progress report. Is that what you're talking about?
Yeah.
That's separate. That's something that's just done.
This was
annually.
the technical questions they had that you had to,
Yeah, they're
and
wanting
you had
additional
to educate the public at the
explanations.
last city council meeting that that's all that was involved.
Yeah, it's. They want more detail. The detail's there. It's just they're not looking in the right spots. So we're trying to point them in the right directions, and there's going to be some red lines
Legal
likely.
details do not conform to commonly held wisdom.
I'm not responding to that, but I do appreciate that comment. So just know that there are pieces that are at work behind the scenes right now. So, and then I think it was the last meeting, or maybe it was the meeting before. I'm sorry, I've got some fog here, but I want to say that we had talked through the different programs that were on the docket for the housing element over the next 8 years. Some in the near term, some kind of midterm, some within that 8-year span.
Colorful chart to that effect.
Yeah, and right now we've got staff working on organizing those and getting those pushed forward. Some of those are going to be coming. One or two of those are going to be coming before this body.
I did send you a question on a new statute. You didn't answer it. You were probably too busy.
Did you send it today?
No, early this week. 2295, I think it is. It has to do with.
Was that SB 2295? Is that the one?
It has to do with. I think it was SB. Yeah, it has to do with school properties. Whether that provision that talked about urban densities and so forth applied to our property.
Duly noted.
Okay.
I do remember getting that email. I think it was on Monday, actually. I got it.
Yeah. Okay.
I haven't responded yet, but I will.
Okay, cool.
Cool. Aside from that, I think we're making progress here.
And,
That's good.
and I think what I heard you say earlier was that at each of the upcoming meetings, you'll be asking if the ad hoc committees have anything to report?
Yeah, I will be actually adding that as a line item on here, just as a standing.
Ah, okay.
It'll be part of this section? Okay.
No rush.
I think I can add. This is where it started. Yeah. Well, we'll work through how that ends up getting, but it'll definitely be on here for our platform.
When's our next meeting?
Self-imposed task
Our next
list.
meeting is November 16th.
Oh, my
So,
God.
I'm not saying that we could probably introduce the discussion
November
at the next
16th. We
meeting,
might-
but
we'll move
probably further down the road in December, start looking at it further.
Yeah,
Yes.
I've got a question on bullet number 2 here. Fire suppression mitigation.
Mm-hmm.
That's mitigating fire suppression?
No, that,
Probably should be a slash between suppression and mitigation.
Are you trying to
Maybe.
correct the grammar here?
Yes, ma'am.
yeah, this,
I can be a pedant too, you know.
it lends itself both to building, but also to planning as well. It's kind of a hybrid between the two.
Well, that was actually where my question.
Or an ampersand would work.
I don't think he's hearing.
I know.
But beyond that, here's the piece. Beyond that, it's really kind of tied to the safety element. And Vice Chair Bennett, were you a part of the safety element discussion that we had maybe 6-8 months? Yeah, you would have been. Maybe 8 months ago when we brought that forward, and I identified that not only is the safety element getting a hefty update, CAL FIRE is going to be involved in it. There's going to be several Assembly bills and Senate bills that have come in play
And
that are
that
all
will
going to
come
have to be a
back to
part of it.
us.
Well,
They're going to either be through policy or through provisions within the safety element itself.
I guess the thing I'm most concerned about is that this be both broad and inclusive of both the built environment and the natural environment. And when we're dealing with suppression and or mitigation, that, you know, for instance, a homeowner needs a variety of things, not in silos, not, oh, well, here's what you can do, but for, with your landscape, separate from, here's what you can do with your landscape, the foundation of your building.
Hardening
roof
the
of your
house and
building,
hardening the yard.
Right,
Yeah, yeah.
all of it.
And some of that is actually through what Quillisi was just mentioning, which is the landscape, which you were mentioning kind of in the beginning of the silo piece.
Right now, there's a company that's heavily marketing sprinkler systems for homes on the outside.
Mhm.
And there's, as somebody who lives on the urban ex-urban interface, I'm very concerned about this issue, and I don't know where to start, or if to start, or if this is the best place to put my efforts, or, and if I'm having that problem, there are lots of people in town who are on that interface and are asking themselves, what do I do?
Mm-hmm.
So I hope that we don't.
Can you speak into the microphone?
Yeah, I'm sorry. I'm just hoping we don't look at it as purely or primarily fuel management.
I think it's meant to be more broad, not necessarily as narrowed and specific as you're mentioning.
Right.
Because that's a very specific and technical piece that you just mentioned. I think it's meant to be more broad in its application, and certainly through the safety element. When you get too narrow, you lose sight of the kind of the bigger picture, and policy certainly helps to drive that.
Will the safety element come back to this body again?
Mm-hmm.
Okay.
Can I follow up on that, for what Jamie just said? It seems like there's two terms that have different meanings, plus there's a term that's not there. So I think in terms of fire prevention, as trying to prevent fires from getting going, which would have to do with fuel, cleaning out forests and so forth, and preventing the fire from getting here. Mitigation is preventing its seriousness. Technically, that term means preventing it from having more damage than it would. So it's not preventing it, but it's mitigating its damage. And then suppression would be, once the fire is on top of us, we bring the fire trucks to stop it. So those are all, to me, different. And I think sometimes we get really confused, and we always think about how we're going to get out of town as opposed to how we're going to prevent fires from coming here in the first place, which seems to me the more important task is prevention and mitigation than, we tend to think in terms of.
Well, when we have something called fuel mitigation, is an asphalt roof replacing it with a ceramic roof fuel mitigation?
I don't know. I could think of fuel mitigation as going out into the forest and getting all the fuel. We tend to think fires happen, why they've happened every 30 years, the fuel buildup. The fuel, to me, is the underbrush and so forth that causes the fire to take off and come at us.
If you read the fire department's literature, their big concern is stacks of wood against the house. And, and
shake roofs.
So I experienced something the other day which really kind of surprised me. I was on, I think it was Drown Street, or maybe it was Montgomery Street, going around, and there's the street right next to the mountains. And somebody on the street going towards there, they were out, working on their yard, and I asked them, "Oh, why, you planting stuff?" No, we're getting rid of stuff because our insurance company, and I'm talking about a little brush. And then I couldn't figure out, I'd go to the next house and there's gigantic trees all over the place. And I asked some guy, I said, well, is the insurance company said you have to get rid of this? So I can see how people are very confused as to what they should or shouldn't be doing. And I thought it was amazing that insurance companies asking them to get rid of brush that's that low on the ground.
There will be guidance
Not from an
in these
insurance
areas, safety element?
You've got to be thinking broader from that perspective versus the narrow pieces that have been kind of discussed here. And I look forward to having that conversation when the safety element comes forward. In the meantime, Is there any other questions in regards to the work plan?
Yeah,
No,
I
no.
do.
Not that one.
Okay.
Quick question. With, we just talked about fire suppression mitigation, tree, and then tree ordinance, water efficient landscape guide, CEQA guidelines, parking study. Could we do something like, and I've heard other cities doing this, is like a green infrastructure zone or an overlay. So we have a housing overlay, right, that applies to some zones, and there's certain requirements like SPL where, certain conditions are overlaid on top of, what we currently have. Could we do something like that with like a green infrastructure overlay? Building out guidelines for like fire mitigation, for like bike parking requirements, for maximum parking requirements, for, gray water capture, landscaping. Could we do something like that? Create a new overlay?
Could.
We could.
Here's, I think
If you think that only part of the city needs that,
Well, you could make the overlay for the
But
whole
general
city.
green infrastructure
or
is the whole
that
city.
means change the code.
yeah,
Well, no,
that,
it's overlaying on the code. It's on top of the code. It's like the housing
That
overlay.
changes the code, too.
It doesn't necessarily change it.
here's what I would suggest. At some point in the near term is going to be another joint meeting with city council. And we always have a meeting before we have the joint meeting. And at that meeting, we discuss the items to either take off, to add, although we're taking them off as we're completing them. So we're completing the tasks, right? And then we're getting credit for it. I think that's probably one where we do a broader discussion in terms of what your thoughts are. I would say look at,
Yeah.
if you want, we can talk offline in terms of,
Yeah,
of what you're thinking
yeah,
to
I
kind
will.
of hone it in
I'll give you some
so that the
examples of some-
discussion is merited. Sure. I get where you're going with that, and I've seen that done, and it's typically not done as a blanket throughout the city. It's typically within specific areas, but I will also note it's typically within larger cities.
Correct.
But given our unique circumstances in terms of what we've got, I think that's out the window. I think it could apply to a smaller city like us. So,
Thank you. Awesome.
Okay? Let's go to item 5 then, future agenda items.
yes. So we have an interesting issue, but there's not much that I think can be done. We have three fairly large items. Well, two I would say that are large, and I think the first one, I think we've done an excellent job of working with the two constituents regarding this to get it to a point where I think there's some good considerations and agreements that have been reached at this point. There's also the appeal of a decision that I had made to deny the request for a gas meter on a vacant lot. This vacant lot is actually a site that this commission saw, I want to say December of last year. So it's a determination that I made per the code. It's through the REACH code. You'll be seeing that as an appeal goes, we've got to schedule it within a certain time period. So this is the last date in which it could go.
Are these 401, 401B, and 401C East Topa Topa, are those proposed new construction?
Yes,
It's an empty lot.
it's currently a vacant lot.
So this is someone who wants an exception to the REACH code.
Correct.
Okay.
That's what we look. That's as far as I can go. You'll have a lot of information that'll be coming to you. And then Gables. I know we've talked about that several times. Because I know there's one commissioner that is going to have to recuse, I want to get kind of a straw poll, making sure everybody, or who is going to be here at the meeting on the 16th.
I'll cancel my trip to Hawaii, but I'll stay here.
Bennett is reaching for his phone.
What do I have to do?
What can I add to my calendar?
But it seems like we've got enough for at least a quorum for the discussion. There is no decision with concept reviews, but I anticipate that it'll be a full house.
You're okay?
Yeah, fine.
Okay.
Yes, thank you.
So we'll have 2 in and 2 out, yeah. I did have one question on that, and maybe it's too soon to ask, but it says senior housing. Is this is this affordable housing, deed restricted affordable housing? Or is it just restricted to seniors by the owner of the property, or?
They're proposing senior housing. There'll be more
It
information.
says that, but I don't know what that means.
That's their proposal. Not deed restricted at this point.
Okay.
Do we have any senior housing provisions in our code?
In
So
terms
this is
of,
just what they said they're gonna do.
No, the density bonus table in the code says you can get a density bonus if you have a certain percentage that is restricted to seniors.
that's a good point.
But it is not restricted to income levels in that portion of the code. It may
And they're
be
not seeking
somewhere else.
they're not seeking a density bonus in this case either.
Oh, okay.
Okay,
Don't need to worry about it then.
all right.
I know on the 7th, it's not identifying any projects, but I think we've got 2 projects that are potentially going to be ready on the December 7th.
Who on the pending list?
One actually isn't even on the pending list, but yes, it will be one of them on the pending list and then one that's not on. That's advanced planning.
Okay. We do have a member of the public who wishes to speak on this item.
Which one?
Would,
Oh,
sir.
Which one? Which one?
Speaking purely as a,
Tab
con-
5.
purely as a constituent item, I'm purely speaking as a constituent, as referenced by the Community Development Director. Number 5, yes, certainly on the item of the Love Social Cafe as being one of the constituents, we do have terms, we do have a agreement in principle, but that agreement has yet to be actually memorialized in detail.
Reduced to writing.
Yes. We do not have an agreed-upon in writing, complete agreement. I would hope this wouldn't come before this commission until we do, because there's no need for it to have to be deliberated if we can come to an agreement and bring a recommendation together. But I just want to hope that we don't put this on the agenda prior to the formal written agreement being completed.
Okay.
The only caveat to that is, and I have to go back and look at the planning commission meeting, is I think we actually did it date certain to this date. But I'll go back and double check just to make sure.
I understand that, but
Yeah.
I responded to one email, and it's been several weeks now, so I'm not sure why we haven't moved forward.
I can talk to you about it offline.
so if they hadn't reached agreement, we would just continue it. Is that correct?
It's possible.
If they reach agreement, then
I mean,
this
they
may
haven't
be
reached
moot.
agreement.
No, it still isn't moot, is it? We would have to recommend to the city council these terms or make a decision ourselves on whatever terms.
It's not a recommendation to city council for the condition. Yeah, it's a decision by this
Commission
body.
decision.
Correct.
It has nothing to do with city council.
Right.
Okay.
I would just hope that, I would just hope we would get to a written agreement, which seems that we're so close
A whole
to.
lot easier if we
Yeah.
had something to agree to.
And I think we're close, it just hasn't happened yet.
Sometimes deadlines have a way of getting to agreements.
I'm waiting.
Thank you, sir. Any other questions on future agenda items? Okay. Then, seeing no other apparent business before the commission at, oh. I have a third hat. Oh, city council liaison. Whoa. Oh, and we have director's comments.
Yes, city as the direct, really quick, okay, because, you won't, I'm soon not, but still city council person until we vote for the certification of results, and I'm,
About
and
6 weeks.
I welcome the new elected officials. But I'm still city council, and Susan and I have agreed that we are going to make a joint request for funding for the environmental study at the city expense, and I'm very much thankful that the property owner has agreed for access if the city will pay for it, and so we will be making that request.
So two of you are making the request, so it will be on a city council
It will be on a future council agenda, if not able to be approved within the city manager's discretion.
Remaining meeting this week, this year,
Well,
first meeting of December.
yeah, but it's kind of, anyway. I just want to report to you as liaison that Susan and I are going to make that request. I still legitimately can make that request because I still am a city council person. Sure. Okay, so, and James is enjoying Hawaii.
No more. No mas. All right. Then I declare at 8:26, we are adjourned.